Bartolini. I'm Professor of International Law here at Roma Tre University. I'm also a member of the board of the European Society of International Law, where I've also been requested to be in charge of the ESIL Teaching Corner, that you might know is a resource provided by the European Society of International Law, which aim to currently include some syllabus of courses on international law made available for ESIL members in case they would like to have some inspiration or make some exchange of experience about teaching international law and their syllabus. In the chat box, I will put the link to the webpage of the European Society of International Law Teaching Corner. But now the idea with the board was to work a bit more about teaching, about the topic of teaching international law, as we consider as a learned society how it is relevant and is crucial for scholars, not just to be professor, but also try to be teacher, in particular of international law, because unfortunately we know how teaching is not, let me say, the most à la page topic, both for research as well as for reflection about the role of academics in our universities. But that's not the case. That's not the opinion of a series of distinguished speakers that I had the pleasure to host today in our event, which basically will kick off a series of webinars devoted to teaching international law that the European Society of International Law is going to organize in the next months. We are going to have other sessions devoted to moot courts, to legal clinics, to the use of videos, arts in teaching, to art performance, even theater performance, to be part of the teaching experience of international law, and so far and so on. So there will be a rich program, so please keep in touch on that. But today, the best option was, of course, to start in light of very unique case, in which basically last year, while for a long period, there were not so many publications about teaching international law. Last year, it was like a boom of publication of very high quality publication about teaching international law by our colleagues here. So basically, I'm referring to the volumes published by Paul Diel and Charlotte Q about teaching international law by Edward Elgar. Then Jean-Paul Gauci and Barry Sander published an edited volume about teaching international law, reflection on pedagogical practice in context law by Routledge, while Peter Hilpod and Giuseppe Nesi edited a comprehensive volume about teaching international law by Brill. So to discuss these volumes and also to reflect about with the authors and editors of this volume, I could not be more lucky to have been joined by two distinguished colleagues who have a specific interest about teaching international law. The first one, close to me, is Jed Odermatt. He comes from the University of London, and I will also post the link in the chat box in a while. He was author of a very in-depth review essay of the 3 volumes plus the further one. He recently published in the European Journal of International Law. And then, of course, I'm very happy also to have Christine Schowel-Patel from the University of Warwick with us. As you know, Christine has devoted a lot of attention about teaching international law, and I would definitely recommend you her Henry for the Oxford bibliography about teaching international law, which is, of course, the starting point for anyone with an interest in teaching international law. So the idea today was to engage with our distinguished colleagues around a series of questions. The first one, which is the only one that I have anticipated to them in order to make the discussion a bit more vibrant afterwards, is a question that is from myself, which basically, so why did you engage in researching about teaching international law? So what was, let me say, the starting point for having you engage in publishing a volume on teaching international law? And also, if you can, let me say, provide some brief insight about the characteristic of your volume. So I will start as the order of the flyer. We have the colleagues from the US. Also, thanks for wake up quite early for us. Paul and Charlotte, please, yes, you have the floor about your volume first.
Okay, I'm going to take the lead on this one. For our motivation, I think the first thing we know is that there's an extensive scholarship about the teaching and learning that comes from pretty systematic research. But most instructors, whether they're in law schools or other units of universities, are really unaware of that literature of how students learn. And most of us have never had the kind of training in pedagogy that we have in terms of the depth for research. And so this was an opportunity to apply some of the knowledge of the scholarship of teaching and learning to the specific context of teaching international law. And selfishly, it also allowed us to reflect on our own teaching practices in a critical way. But I think the overall goal was to improve the instruction for everyone who teaches international law. In terms of the main features of our book, first, there's a continuing thread throughout all the chapters about the importance of establishing learning objectives. For what do we want our students to learn? And we rely heavily on Bloom's taxonomy of learning goals and objectives, something that's widely used in all levels of education. And Bloom's taxonomy ranges from goals of having students remember things, to apply them, to analyze, all the way to the top of a hierarchy about creating new knowledge. So using that kind of framework, we start to look at all the things that are done in teaching international law. The general theme, I think, throughout the book is that the objectives that we have for student learning and the pedagogical approaches that we employ vary a lot by context, and should by the context or audience that we have. For people who teach international law, some of us are teaching to law students, others are teaching to undergraduates, others are teaching to professional master's students, and still others have classes on international law to PhD students. And not just the audiences, but the educational context vary substantially by the university and by the country around the world and the educational systems that they adopt. Within this kind of framework of both learning objectives in the Bloom taxonomy and references to being sensitive to the different contexts, the book discusses a series of different aspects of teaching international law. The content of international law, of what kind of topics and things should be covered, the delivery modalities that we employ from traditional lectures, the case study kind of approach, active learning kinds of approaches, etc. The assessment, whether one uses exams, small exercises, papers, etc. And ultimately the role of theory drawn from international relations as well as legal scholarship. And so within each of the chapters, which are devoted to each one of those kind of four things, content, delivery modalities, assessment, and the role of theory, we try and discuss the advantages and disadvantages of different approaches, make a series of kind of recommendations, and ultimately try and discuss how there might be some variation in each one of those according to the different contexts that we have. Thank you.
Thank you, Paul. Thank you for this interesting overview of your book, which is the only one which is co-authored by two authors, while on the contrary with Jean-Pierre and Barry, we moved to the first of the two edited volumes. So Jean-Pierre, yes, you have the floor.
Thank you very much. And first of all, thank you very much, Giulio, for the invitation to be here, and to Christine and Jed and others for engaging with the books and with the number of books that have come out on this topic in the last year. So I think the inspiration for us to put the volume together comes from the inspiration to put a webinar series together, which comes from an inspiration to put a conference together. So around 2019, both Barry and I kind of were simultaneously looking at two kind of separate pieces of work. One, which is directly mentioned in our introduction, was a lecture at the Lauterbach Center in Cambridge by Joseph Whaler, discussing basically taking teaching seriously. I think it was entitled Taking Teaching Seriously. And the other was me looking at proofs of a an anthology that I was helping pull together at the time, and looking at Gary Simpson's On the Magic Mountain paper. And on the basis of both those things, Barry and I had a conversation over Twitter, no less, and we started pulling together a call for papers that eventually went out for a conference that was supposed to be held in, I believe it was May 2020. Needless to say, that got delayed. Instead of the conference, we switched to a webinar series, which was actually a welcome kind of change, not least because of the number of excellent submissions that we had for that call for papers that we wouldn't have been able to include in a 2-day conference. It would have taken considerably longer. So having the webinar series did allow us to engage with a wider audience or a wider set of papers at the time. So that's kind of where the idea for the volume came from. On a kind of slightly less practical sense, I think both Barry and myself are kind of in, or at least at the time, we're in the slightly earlier stages of our careers, both engaging in teaching. Barry was taking on a new role as assistant professor. I had just taken the role of director of teaching and training at BICL. We're both engaging in teaching of international law, but to very kind of different audiences, or audiences at different stages in their career. Barry primarily teaching kind of at the university, in a university setting, myself teaching more at the kind of at the institute and through in-house training to companies, but also governments and courts, about kind of various aspects of international law, both general international law and particular areas within international law. So we wanted to kind of have the opportunity to learn from what others were doing, but also to start putting people together and to start or to contribute to the conversation that was kind of starting around kind of some of the approaches to teaching international law. So that's, broadly speaking, the inspiration behind the book. In terms of the book, I think, as you all know, it's an edited volume. It's organized around kind of 4 key topics. So the first one is reflexivity. The second is on tools and techniques. The third on context, and the fourth on specialized areas. And I will say that kind of configuration is, one, the result of a lot of back and forth and discussion around how do we kind of organize the chapters in a way that makes kind of logical sense, but also where the logic of the organization of the chapters makes a point in itself, but also is kind of one option of how we could organize the chapters. And there were many other options that we could have gone with, but eventually we settled on the one we did. And I think there's 3 kind of key things that we're particularly proud of in terms of the book. So the first one is the diversity of contributors that we managed to involve in the chapter. And I'm incredibly thankful to all of the authors for their contribution, their ideas, their insights, and the generosity with which they engaged in this project. And I know there's 2 of those authors on the call today. So thank you very much to you on behalf of all the other speakers as well, all the other authors as well. Sorry. But the diversity wasn't only in terms of contributors, it was also in terms of kind of the geographic reach, the epistemic reach of the various audiences, as well as the audiences that the people writing in the book were teaching to. So we have authors who teach at universities, authors who teach in military academies, authors who teach through NGOs and through international organizations. So there was quite a variety and the diversity within those contributors, and the possibility of having a conversation between those contributions. The second is that we were able to include pretty significant critical and reflexive approaches in the book, whether that's chapters around kind of decentering the international law teacher, whether that's how we use history to challenge historical narratives, etc. And then the final thing, and obviously this is also a product of the time when we were working on the book, with the ability to talk about teaching during crises. And that obviously involves COVID as a crisis, but also obviously armed conflict, etc. And we had a significant number of contributions that were dealing with how do you teach in the context of crises around the world, in the context of armed conflict, etc. So we had a contribution from, or a series of contributions kind of encapsulated into one by the International Committee of the Red Cross, for example, that talked about kind of building awareness and capacity building around international humanitarian law in the context of various conflicts around the world. I think I'll stop there, and I'm running out of time. So,
yeah, thanks a lot, Jean-Pierre. Last but not least, Peter, who has produced this in this volume with Giuseppe Nesi about teaching international law as well. Please, Peter.
Many thanks, first of all, for this wonderful initiative. I think it was really overdue, and this is really a fine coincidence that it happens when so many volumes are published close one to another. Inspiration, what is the source of inspiration for this book? I think there were many sources of inspiration because I've been thinking about such a project for many years. So there was curiosity and surely a professional motivation in the sense that I've come to ask what is the basis of what we are doing, how can we excel in our activity, and what, if any, is the impact of teaching. Generally, I would say that we are, I currently come to this conclusion, we are enormously privileged to be in this profession. It holds enormous promise, as Samuel Moyn, as we all know, has famously stated that human rights is the last utopia. I think this is true for international law as a whole. So we all, I think, hope that we can change things for the better. And in this, we are standing at the shoulders of giants. And for this motive, it's also very important to study these works because we have whole generations of international lawyers who have looked into the abyss, who have resisted oppression, and who have written groundbreaking pieces of timeless relevance. If you only think about the works by Herschel Lauterbach, Louis Sohn, or Louis Henkin, or more recently, Antonio Cassese. And so the question arises, in which sense could we take an example from them? Should we stand up against injustice? I think so. I think this is important. But if we do, what is our real impact? Are we at least able to instill this spirit into the younger generations? These are all questions that have come up, and I think that studying the teaching of international law is closely connected with all this question. And I think also that we should not distinguish so neatly between teaching in a narrower sense and writing. These two elements are closely interrelated, but perhaps we will have the opportunity to discuss about this topic. Then teaching also means learning. So this is another fascinating aspect of our profession. If we study teaching, we learn a lot about history and philosophy of international law. I can only recommend this book edited by Antonio Cassese, 5 Masters of International Law. I think this is a very important book in this context. He interviewed 5 eminent international lawyers, and he gives there in this book fascinating insights about the identity of renowned international lawyers. So I would say in sum that to know about teaching is to know about the meaning at the end of our discipline. And ultimately also it's a very personal thing because we understand our own identity. Briefly about the main characteristics, only 3 words, the main characteristics of our book. We asked what are the main challenges in this field. I think one of them is surely academic freedom, and it's also interesting to see that this topic has become so prominent in the last months and weeks. Then another question, does the Humboldtian perspective of university teaching apply also to international law? So the research-informed teaching, I also believe that this is the case. Then the value issue, up to which point international lawyers should stand up for values and by which means. And then we intended to provide a broad panoply of views and insights on teaching by different, mostly very renowned lawyers and teachers from different disciplines and subdisciplines like international economic law. We also studied new instruments of teaching like cinema and the law. At the same time, I would like also to anticipate already at this stage that we consider this book work in progress. There is no definite account of teaching, of course, and there will never be. This project has to be continued, and it will be continued. We plan further conferences on this subject already for the next academic year in Innsbruck. Thank you very much.
Thank you, all of you, for, let me say, encouraging, so also from my side, encourage all of you to have a look at the volumes. I put in the chat box the links to the volumes, so you can access, well, you can look through your libraries to access them, and definitely rewarding experience. So now let's start the discussion with our distinguished
Giulio, if I may,
yes,
sorry to intervene, but just two quick things to what my colleague Paul Deal had said before going to the general discussion. First of all, thank you. I joined the others in thanking you for organizing this. As some of you may know, teaching international law has been a great interest of mine since my long tenure at the American Society of International Law, now more than a decade ago, 2 decades ago now. But just 2 quick points to what Paul said with regard to what inspired the project. In addition to what he said, it also seemed that this was a good opportunity to reflect on the many challenges and changes that international law itself was undergoing. So as we thought about teaching, it was just what is happening to international law itself. And indeed, the question of, is there any significance or relevance to teaching this as a subject unto itself, or has it become so integrated with many other things that indeed focus in that way might be a better approach? So that was sort of a general question. As a result of the generalized interest in international law coming from different topic areas, different contexts, there's also lots of teaching about the subject. And so the question is, so what is the essence of international law that should be touched upon by everyone, no matter what the context, no matter what the occasion? And a lot of this thinking, if I may say, was inspired by Peter's generous invitation to me, Hilpold, to participate in his workshop and the chapter that I contributed in his volume, just sort of what is the essence possibly of international law and what needs to be taught. So I just wanted to throw those 2 things out there too, but thank you, Giulio.
No, that's very relevant also to pinpoint how honestly also the American Society have been a bit more on the page on that with the theories of, they also have an interest group on teaching, which is something which is not yet present in the European Society of International Law, but there could be some interaction, I think, among the 2 societies about teaching. So I have with me Jet, who very kindly accepted our invitation to join us in Rome. It is very hot, I would say, today, unfortunately. So thanks also for this additional effort for Jet. Jet, so the problem is yours.
Thanks, Giulio, for organizing this and for the authors for joining us for this discussion. A lot of you in your presentations this morning, today, mentioned the idea of challenges. And I wanted to ask you about one of the challenges that comes up from the books and from the other literature on teaching international law, is that there's a challenge of doing justice to, at the same time, the so-called core of international law, topics like statehood, jurisdiction, responsibility, and so on, while at the same time integrating critical, theoretical, decolonial, interdisciplinary, and other approaches, while still doing justice to all of them. So I wanted to ask you about how you would approach finding the right balance to this challenge, and whether you think it's still correct to think of a core of teaching international law that needs to be covered in teaching. That would be just maybe for all the different.
Yeah, if you can still follow the same order, so it's easier for us to follow the same order. So it could be Deal and Jean-Pierre and Peter. Yes.
I think there's a need to look at those critical and decolonial kind of approaches, but I also think it's a mistake to treat those as separate from the core and looking at different perspectives. So rather than having a section of the course, oftentimes at the end of courses, which is common in my discipline, international relations, it's sort of treated as an afterthought of somehow it's different or not as good, is to look at the core issues, for example, of state responsibility or territory or some other kind of views, and make sure that those alternative perspectives are reflected within those particular topics and not somehow separate or inferior to do so. So to me, that's a lot of that gets at looking at the global South perspective. It looks at how international law was formed in those kind of areas. It leads you to ask the question of whose interests are served by the current rules. How would those from a different culture or tradition analyze the same kind of rule? So to me, I would embed it within the core rather than separate from the core.
Charlotte?
Yeah. I would just add to that. I think I would take the context, whether you're teaching a full survey course or this is part of another course where this is an element, and draw on the elements of that context to actually expose the evolving thinking related to how international law functions in those contexts. So whether it's trade relations or environmental law or human rights, there has been a development which the subject itself has contributed to international law's understanding. But then, also going deeper possibly into integration with the domestic legal system, since I teach in a law school. So that's the principal interest. So I think you draw on the context to weave in how this is a dynamic, evolving sort of subject, as I believe all law is, and try to reflect on how these interactions then actually give rise to either questions or new normative development or new structural development, wherever that might go. So it is for the instructor to have the core in mind. You use that as a basis around which you then have further discussion, and then you sort of unpack and assess, after that is completed.
Thank you, Charlotte. Jean-Pierre?
I'm not sure I have too much else to add to what Paul and Charlotte just said. I completely agree. I don't think we can separate out the kind of approaches to thinking about international law from those core subjects of international law. And I guess one way to think about it is the kind of skill versus substance of teaching international law. So the approaches to think about international law, whether that's crit, whether that's third world approaches, etc., is the skill with which we then approach all the other subjects of core international law, or even kind of more specialized areas within international law, never mind only the core subjects. I think very often I find there's quite a bit of kind of thinking around those approaches. But as Paul mentioned, it tends to come kind of towards the end, because we assume that students need to know the basics in order to be able to think about them critically. But actually, they need to know how to think about them critically before they can kind of learn something that then they need to unlearn to take that kind of more critical approach later on. And I think that's kind of, it's a bit of chicken and egg or cart before the horse situation, where that skill becomes more important than the substance, because the learning of the substance needs to be informed by those kind of approaches, which I think of more as kind of critical thinking skills rather than anything else.
Peter?
Yes, many thanks. Yes, I fully agree with the speakers that presented the thesis before. Only a few considerations. I also think that critical thinking is very important, and for me, it's also pivotal in teaching. Perhaps not for the introductory course, even though I also mention these critical aspects, but it's surely fundamental for the advanced course of international law. There is an interesting chapter in Möckli International Human Rights Law, which I consider an excellent manual, by Marie Dombour, who treats these critical aspects, critical international law theory, then utilitarianism, Marxism, feminism, and also post-colonialism. And she mentions that usually these topics come towards the end of the classes when no more time is left for these issues, and then they're no longer treated. And so this is really a pity, but I think that this aspect, critical legal theory, gains more and more importance. But this is also an interesting aspect to compare manuals from continental Europe with manuals from the Anglo-American world, and especially, for example, from Australia. I see that in Australia, really great importance is attributed to critical legal theory, while in traditional manuals in continental Europe, often this aspect is not treated at all. There are manuals where this thinking is not even mentioned. And I think this problem should really be addressed. I don't argue that we should have uniform manuals on international level, but there should be some consensus on the syllabus. And I think that critical legal theory should really be part of any manual. As Jet mentioned, post-colonialism, perhaps this is one of the most problematic aspects, because it is very much on vogue. This is true. We had a conference lately in Berlin by the conference by the Society of Comparative Law, and there also it appeared that there are so many different meanings to these concepts that there's no real consensus. We see that there is much critique about post-colonial criticism. There is even a post-colonial post-critic, and so one could discuss for many hours about this issue. But at least it is important to know this concept, to know the many meanings of this concept, and so I think it should be part of any syllabus. And I think this is also a very important aspect for perhaps for comparative considerations about teaching international law. Thank you.
Yeah, thanks for this point. Also, the textbook, for sure, that's a significant part component of teaching international law. And indeed, one of the next webinars will also be devoted to textbook and their role for teaching purposes, because of course they are sort of in the case of a signpost of what professor can teach, because of course the starting point will be the choice of the textbook to be used, which of course, as also said, it could be a bit more critical, it could be a bit more traditional, and of course this makes a difference in terms of what you propose to the students. That will be a topic for one of our next webinar. Christine, of course, I think you can also reply if you want also even to this question, but otherwise you can jump on your question for the speaker. Thanks.
Yeah, great. Thank you for the invitation, Giulio, and for organising the webinar. And to the authors and editors, I also wanted to say congratulations on the publication of these books, and thank you for your scholarship. It's really great to be in conversation on teaching. So I wanted to pick up on a couple of things that were already mentioned. So Jean-Pierre mentioned teaching during times of crisis as a theme that recurred in the edited collection, and Peter, you said you mentioned the international lawyer as someone who stands up against injustice. And Charlotte, you said that one of the motivations was to think also about what's happening to our discipline. So arguably, no matter how long we have been teaching for, it's been in the context of crisis and crises. And so for me personally, I started teaching shortly after invasion Iraqi freedom at the time of the Iraq War, and was plunged into these discussions of anxieties of international lawyers as regards adopting an anti-government stance, and also the spiraling anxieties of influence of critical international lawyers and their positionality as defenders of legality, famously voiced in the We Are Teachers of International Law reflection, which seems to be one of those pieces I return to again and again and again. So the dominating crisis today is, of course, the genocide in Gaza. And we become aware that even if we are not comfortable with this as lawyers, we have to take a stance in our teaching. So we're not only witnesses to a genocide, but we also know that due to our privileged knowledge of the laws of genocide, international humanitarian law, generally the laws on conflict and restraints on human suffering, we might be complicit if we do not take a stance. And I believe that for all its shortcomings, the ICJ has done the more politically timid international law educators a favour here. So there's a lot at stake. There's complicity in genocide, the potential moral bankruptcy of our discipline. Coming back to this question that Charlotte posed of what has happened to our discipline. I mean, I'm sure you have noticed too that there is an influx of reflections on whether international law is dead. What I wanted to ask you then, in the knowledge that the books we're discussing will have been written prior to October 2023, I am keen to hear how you, as colleagues who have reflected on teaching international law, have dealt with teaching international law in times of genocide.
I'm going to let Charlotte answer first, and I may have a very different view than Christine.
Okay. First of all, I think this is such an important question. I also, as you were speaking, was reminded of the essay that I think Hilary Charlesworth wrote at one point about international law in crisis. And what she revealed in that reflection was that how our approach and use of when international law seems to be salient during times of crisis actually has outcomes that may privilege certain interests and power structures that, in fact, we may be concerned about. So her plea was that one actually reflect upon international law in some other context other than always in crisis. So I think what the times that we presently experience perhaps also speak to that with regard to, so who's paying attention, who's not paying attention, who cares about this, what effect do these things have? You know, these really in very real ways unpack all of these kinds of issues. I think to me, and I've had to think about this because I have been having to prepare my syllabuses for the fall, is that whatever the circumstance, international law remains in some form, in some structure. The manner in which it operates, what it can do, who is handling it, and all of that remains. It may change, but international law per se is still there. So the question is to understand exactly short-term, long-term, and for whatever goals and perspectives we believe international law tries to pursue as part of just general social order, you know, how that functions. So I think it's a reflective moment to see, first of all, what has happened to these norms over time, what specifically is being asked of them at this moment. Why or why not do we believe they don't seem to be working as well as we may hope? I also had, in the context of my another project, reread the century-long history of the American Society of International Law, where from the moments of its founding in the early 20th century, it has been trying to address crisis. So I think the question you pose, the challenge Hilary puts to us, just our own reflections right now, I think we should think about why we maybe international law as responsive to crisis is not actually the best approach to handling understanding of international law and its function.
Okay.
I think Paul wanted to come in after Charlotte, or?
I'll let you, I'll come in last. There's no reason why I should be first all the time.
Fair enough.
Okay, you can mix a bit the order for sure.
Yeah, sounds good. I think I have, well, two parts to the same answer. So the first is that I think silence is complicity and silence is endorsement. So I don't think we can realistically kind of claim any sort of kind of morality to our discipline if we're not taking a stand in this context. And I mean, as you rightly said, Christine, I think the ICJ did us all a favor by giving us kind of a backing for taking that position. I don't think we needed it. I think international law is relatively clear, but I think it does give teachers of international law a kind of a backing for taking a stand. I think the other side of it, when it comes to kind of questioning the value of international law, when it comes to questioning kind of what international law actually stands for, in these contexts where we're seeing kind of these kind of violations that are going without accountability, I think is to also think about kind of the day-to-day international law, the areas of international law which do work and which do influence people's lives, whether it's, you know, getting on a plane or whether it's receiving something by post from a different country or whatever else. And I think that's where that kind of critical thinking skills that we were talking about before comes in as important, right? It's something can be kind of useful and problematic at the same time. And there are obviously issues and question marks around kind of international law that are being highlighted at this time, but that have always been issues with international law. And I think crises do highlight, obviously, some of those issues. But there's also the other side to it, which is we had the COVID crisis. Yes, international law had issues within the COVID crisis, but we've also seen kind of development since around kind of the pandemic treaty, around the disasters, etc. So we do need to, I think, keep kind of that side of it alive with our students as well, kind of the knowing that international law isn't just about the kind of big news items. It's not just about Security Council. It's not just about the laws of war and kind of human rights broadly understood, etc. It is also about kind of day-to-day relevance of international law to individual people's lives. That doesn't take away anything from needing to question whether the structures that we have in place for international law, and specifically to deal with issues like violations of international humanitarian law, genocide, etc., are up to scratch, and whether they are being ignored, but also whether the reason they can be ignored is because the system behind them isn't quite what it needs to be. If that makes sense.
Yeah.
Yes, these were very important points that were made before. I think that these are topics that are also discussed at many international conferences, and I can agree with all the speakers. Christina mentioned moral bankruptcy. Yes, but I remain nonetheless optimistic. I also agree with Charlotte and Jean-Pierre. If Jean-Pierre said in international law there are still things that work, so we can say that the traditional international law still offers sufficient elements to address these issues properly, or at least in part. But it is important, of course, to expose the deficits, the power structures, as Christine mentioned, the many lacunae of international law that always have been present, and we still have. But at the same time, I also think that we should take care to attribute to this current affair the right proportion. Not everything what we feel to be revolutionary will turn to be in the longer run so groundbreaking. But of course, as we live now in the present, perhaps we are most impressed, of course, by the events that take place these days. And I also have to say that if you look at some events, we are obviously inclined to assume that they constitute a turning point, like Scholz, former Chancellor Scholz spoke about the Zeitenwende, so it's a turning point. But let's hope that we are wrong in this. Should we stand up as international lawyers against such events? Yes, I already mentioned that I'm of the opinion that we have this duty, because we are in this privileged position. Our words are listened to, and then we should use this opportunity. But then a further question, I think, arises. Should we address the issues that are closer to us, or prefer to tackle with events of universal relevance? I think that on both levels, the challenges are endless. Only to make one recent example, I think that many of you will be acquainted with. You probably heard about the letter of the 9 of May 22 of last Thursday. So it's a very recent event. There are 9 leading European politicians have posed the question whether the European Court of Human Rights has gone too far in its interpretation of migrant rights. And immediately some international lawyers weighed in and asked for the abandonment of the Söring jurisprudence. They said, yes, we are also for the highest fundamental rights standards, but those who have committed serious crimes have forfeited this protection, they said. I find such a statement outrageous, and I openly stated this, and also published first articles in journals about this, and others will follow. I try to make clear that it is not for 9 governments out of 46 of the European of the Council of Europe to dictate to the European Court of Human Rights how this court has to interpret this convention. These are dogmatic academic questions in the stronger sense, and I think we are called here to take position. And furthermore, to deny fundamental rights to offenders would not only undermine the convention, I think, but it would be of no help to solve the migration problem. So this is pure populism on the back of the weakest. And of course, this is an issue perhaps which will not be followed so closely in the United States. It's more a European question. But at the same time, perhaps we are first of all called to take position with regard to events that we can perhaps influence. So this is my opinion. But at the same time, of course, also universal events have to be addressed. But only to say that there are so many issues we are called to stand up. That we have, of course, also to be selective, but important is to do something. And there are colleagues that never criticize anything, that only concentrate on teaching, if at all. But I think this is not enough. So this is my opinion.
Okay, I have, I think, a slightly different view of approach, but probably to the same end. I teach undergraduates in political science in the United States. And I've also spent 20 years of my career running teaching centers that cover all the disciplines at different universities. So I'm sensitive to using the classroom as a platform for advocacy, and I strongly am against it. Having said that, I started this about 10 years ago. The first day of my international law class, I start out by talking to say that this course is about what international law is, and that students should think about what it should be. So when we make a statement that Israel has committed war crimes, or that Chinese actions against the Uyghurs do not fit with human rights law, those are statements of fact. and not my opinion or the opinions of others. And we try and work so that the discourse is focused around that particular aspect. And my job is not to tell them or criticize them. Now, having said that, there are a number of ways that I think we meet the challenges of the contemporary crises and problems and things. And I do it in several ways within that context. First, I begin every class I have by bringing news stories that reflect on international law. And frequently they're about actions of states or individuals. They're about international law itself, which reflect that there are violations occurring. That is not necessarily per se that I talk about criticizing them, but I'll say that this happened, or these kind of statements are there, and this does not fit with that. Or I'll ask the students about how do these actions fit with the rules you just learned. The net effect is, maybe to call out certain kinds of violators. It starts a conversation about international law, how it might be improved, how Genocide Convention covers a series of groups, but is silent on political groups, and things like that do that. This other thing I do is I've adjusted the kinds of topics that are covered in the class and the depth that are given to them. So it's really been in the last 5 years that I've spent more time under human rights covering the 51 Convention on Refugees and Migration and the 67 Protocol. And we talk about what those kind of obligations are. And there are references to examples, not just from the United States, but the UK to Finland and others on actions they've taken that don't seem to fit with what the requirements of those conventions are. Things like that. There may be other things that we talk about, expanding the rights of anticipatory self-defense, and asking the students then about, what if we expanded the rights? Here's what the law says. What are the proposals to expand that right? Who benefits by that? Is this a right that would be available to all states? Technically it would be, but de facto, is this a right in a political science sense that could exercise by only a few states? And so I think we get at the idea of being contemporary relevance, which the students crave. It brings out where violations occur. It talks about the weaknesses and the strengths of international law, but it doesn't do it from starting out for a point that the role of the instructor is to play the role of an advocate for that. It's to develop students' critical thinking skills so that they can develop their own kind of ideas about that. So I don't think I've abandoned my obligation to be a critic, but I've put it on a rhyme, particularly in a context in the United States where claims or arguments about bias of university instructors, particularly under the Trump administration, can get you into trouble by saying certain things, that I try and take an approach that this is part of a conversation that we have about what the law is, and students to develop ideas about what the law should be and to make their own judgments about when violations occur.
Giulio, if I can just add two quick things to that. One is, I think, again, and this will vary depending on the teaching environment. So in the states where some of our classes are smaller, or even in a large class, I think the ability of the students to receive certain information or even passively or actively participate in a discussion, I think we need to also pay attention to with regard to how we address these issues, because students will have views. You want to sort of get them out there. You don't want to feel like you're silencing anything, because this in its own way is also, taking a stance of some kind. And so there is that kind of managing the issue and making sure the students are ready, so to speak, for engaging with the particular subject matter that you're putting before them. The other is, in some of these issues, there is not unanimous opinion in terms of, what may be right or what may be wrong. I think we can agree that a question has been raised, but what kind of question, what level of question, what do we do about this question, that sort of thing, I think we also need to pay attention to, so that the end result of the discussion, or whether it's taking an active or passive stance in discussing controversial matters, is not that so it really has no relevance at all, because in fact nobody can agree on anything. And I think that is not the place that we want to end up. The place we want to end up is that, yes, there are open things, but it's how it is that we are attempting to address these open things, whether for this moment or for another. I think this is also important, and particularly I think in teaching any undergraduate populations. you sort of don't want their first impressions to be ones that cause them to turn off to the topic or the difficulty to engage altogether.
Oh, thanks all of you for this very pleasant.
Excuse me, could I briefly intervene in this and at this point? Would it possible?
Yeah, Peter, very briefly because we want to move ahead. Yes, very briefly.
Only yes, briefly, because I have the impression that we are a little bit speaking about different issues. On the one hand, we have the teacher in the class, and I also totally agree that we have to avoid any advocacy, and we have to stick to norm as far as possible, of course. But then the other question is, does the teacher has a functional role in the public? If, for example, they're advisors to the government and they say things that are completely wrong and they could lead to decisions that are really problematic on the international level, does the teacher have a duty to intervene? So this this double role, this double head should also perhaps be an aspect we should discuss about. Thank you. Excuse me.
It will be good whether they will keep a proper position in all instances in which they act, let me say. So let's move now.
Julio, can I
Yes,
also I just wanted to end with a provocation, if I may. So thank you. That was really instructive, and perhaps I'm also just more comfortable with the idea of being an advocate in my role as educator as well. But I wanted to just pass on a provocation that I give to my students. So and so one of the recurring themes has been international law is not working in certain areas, but it is working in others. And I agree that it is certainly working. You know, when we think about investment laws, trade laws, it works perfectly. But is it really the case that if we think about genocide, that international law is not working as it was intended to be? Because one of the provocations that I give to my students is, what if we think about this in terms of it is actually working how it was intended to work in terms of its history of colonialism? It was always intended to have these racial biases in particular. So that's something that my students often feel more comfortable, and I think as educators we feel more comfortable with this idea of saying, oh, that bit of international law is broken, but it's more difficult to deal with that provocation. Perhaps it is actually working as it was intended. I'm of course not the first person to say this, but I think it is a good provocation for us as educators also.
Yeah.
And I think migration law and refugee law are a clear example of that. So beyond kind of genocide, etc., but there are many other areas of international law where the problems with how the law is being applied is exactly the law working in the way it was intended to work, both at the international level and in some ways more so at the national level. But yeah.
And there is definitely a way to work with students to engage them much more than sometimes it's happened in common teaching.
Yeah,
class.
I mean, think of it this way. That is a great way to have students to think of it. But I also think it brings in the possibility of informing students about when and why the law was formed. And when you get into things like international humanitarian law and the treatment of prisoners of war and others, that was done very particularly in a post-World War II context. And who's a prisoner of war doesn't make a lot of sense for contemporary kinds of conflict and things like that. And there's a series of other kinds of international law longstanding that was done in a different kind of international political context and different challenges and how we change. And so I think it's useful to talk about things such as drones, which I think fit reasonably well within contemporary international law and conflict, and cyber war, which doesn't particularly kind of well. And I think students know a lot about those kind of things and sort of challenging them to say, does the contemporary kind of international law still meet the new challenges we face from technology, cyber war, trade, internationalized civil war, non-traditional armies, things like that. They're aware of all those, and I think it's those kind of provocative challenges that get them to think about how international law works or doesn't for the kinds of things that they're going to face in their career, long after we're no longer teaching.
Yeah, which is also a way, like you said, to go back to the original question by Jed about different, we say, methodological approaches, but even if you don't endorse a critical approach, you can still make your class a bit more critical in terms of engaging students with not the dry and legal text, but with the content, with the origin of them. So let's go back to Jed. And let's see what it might be. Second question.
I'd like to move the conversation to something that Paul and Charlotte mentioned in their opening statements about their books, and that was the use of pedagogical theories. Paul mentioned things like the use of Bloom's taxonomy, for instance. And while it was great, we had this conversation about teaching international law, and there's this renewed interest in teaching international law. What I think sometimes is missing is this engagement with the pedagogical literature and theories of teaching and learning. And one thing that I see missing in some of the books, well, what we often see in these books, in the discussions, is often personal reflections and anecdotal examples of what worked and what didn't. And I wanted to ask you whether or not international law needs more theoretically informed and empirical studies on classroom experiences, things like experiments, case studies, and more engagement with certain pedagogical theories to understand international law. So I would ask you just also about your books and the engagement with those kinds of empirical and theoretically grounded studies.
Jean-Pierre can start with him. Change.
So I think in our book, we have a number of those anecdotal reflections on kind of different things and how they work. So whether that's simulations, whether that's use of particular tools like VR, whether that's use of particular kind of techniques in teaching, etc. We also have a couple of chapters that did undertake some of that kind of more empirical kind of research. So I think one of the chapters is based on a survey of, I think, about 150 kind of respondents, and another is based on kind of reflections of kind of a relatively small group of kind of semi-structured interviews, etc. So there is some reflection on that, but I will say that I think most of the chapters are kind of based on kind of reflections based on individual experiences in classrooms around the world. Does kind of international law teaching need more of that kind of wider kind of pedagogical thinking more broadly? Yes, I think so. I think there is some of that kind of developing in terms of kind of how people are approaching teaching kind of across different countries and across different regions, etc. But I do think there needs to be more kind of an evidence base for some of those kind of broader thinking around kind of how we teach international law. And I think the other kind of question mark that I have within kind of that question is what do we consider to be international law when we're talking about teaching international law? So if we're talking about teaching migration law, if we're talking about teaching human rights law, etc., is that part of what we're thinking about when we're saying kind of international law? If we're talking about teaching of kind of domestic law, which is heavily influenced by international law, so human rights law being a good example, is that part of the same kind of conversation around teaching international law? And should we be including that within that kind of wider thinking around teaching? I don't think that's actually answered your question, but I'm not sure I have much else to add to it.
Nice. Charlotte.
Yes, I mean, I think, understanding a little bit more of what we're doing, what we're trying to do, and, techniques to improve that. So yes, I mean, information, data is useful. I guess the problem is to get meaningful data. So it may not have to be, huge sets of data. But a survey sometimes I think can be limited. People don't reply. But I wonder if something that is more, there's a particular issue we're thinking about and we're inviting perspectives, and so answer the following 3 to 5 questions or something like this. Something like that may provide, and so these can be targeted towards whatever aspect of learning outcome or context, or even Christine's very good question, poses for us. But I think that accomplishes 2 purposes, which might engage better and more thoughtful responses and therefore more meaningful data. It causes the recipient to actually think about what you're asking and maybe cause them to think a little bit, which is, I think, a good thing, and then give you more thoughtful responses. So in general, I would say the answer is yes. I would then plea to make such desires, such projects to gather data, ones that can be meaningful both for the participants as well as for the data gatherers. Because otherwise it seems very generic, and you spend about as much time as then you have the attitude towards the questions, which I'm not sure provides the best outcome, even if you can gather data.
Peter and Paul?
Yeah, on the one hand, there's extensive studies generally on pedagogy, for example, across different contexts. So, for example, there are various studies on how to use active learning techniques to get students in very large classes engaged. So we can draw upon a lot of that information and the techniques, and there's a good research base for that. On the other hand, those general kind of precepts, while they're useful, they may not be exactly the same across different kind of contexts. So what an instructor in biology uses, in these, let's say, a large class, may not translate exactly the same in a large law class of law students and things. And so what we could really use are studies within the international law context that talk about the portability of these general kinds of approaches or ideas or innovations, and whether they work in particular international law contexts in the subject matter, and what kind of adjustments might need to be made. And to do that, and to have that scholarship of teaching and learning that is more discipline-based, it's found much more in chemistry, engineering, and a lot of others than it is international law. Charlotte and I looked for a lot of studies on particular kinds of teaching international law, and there's not a lot. But there also has to be space within newsletters and journals for that kind of scholarship. And generally that's not true, or it gets dumped into a little bit of newsletters which don't have the same kind of prestige or readership that traditional kind of law review articles or analyses have. So in some ways, creating that kind of space for discussion and scholarship, I think is a prerequisite for encouraging those kinds of studies. And I think there's a lot to be done by learning from the general scholarship, teaching and learning. But there's a lot of interesting work that could be done to see sort of what works within the international law context.
Peter?
This is a very interesting topic. I must say that when preparing our book, we studied. It took 5 to 6 years to prepare this book, and so we had plenty of time also to investigate these questions, and we came to interesting results. First of all, we considered also teaching tools. For example, there's a chapter on cinema and the law. We see that in many universities now there are whole courses on this topic, and this is highly interesting. I think this could be further developed. With regard to pedagogy, in a narrower sense, we contacted education faculties, and we noticed the following. It's interesting to see that, of course, pedagogy is taught at universities, but they are teaching teachers that then will work in high schools, not at the universities. So there is next to no no knowledge about instructing university teachers, because university teachers think they're so competent they do not need instruction. They're at the highest level, and so they know everything. And so we see it also at the university when courses are offered for university teachers to get better acquainted, to improve their teaching qualities. They are not attended by professors. Only young assistants can be constrained to attend these courses. So there is a real lacuna. I contacted colleagues in Germany. There is a new journal about teaching law. And so this, this would be highly interesting, but they told us they have no competence in this field, and they would be highly interested to cooperate, but they have, for the moment, no one in the advisory board who could assess these studies. So to sum up, I think this is a real lacuna, and here much could be done. Some professors of we had then some professors from the education faculties, and they submitted papers, but these papers were of no use, and they spoke a different language. They didn't know anything about law, and even less about international law. And so I think that here really much has to be done. And then a last point, I think to motivate colleagues, professors to engage with these issues always requires to offer them incentives. So there have to be chairs in this field. There have to be some consideration. They have the possibility to make a career in this field. And so I think the whole university system has to adapt to these new needs. But there is surely much to be done in this area. Thank you.
On that, there is for sure a lot of differences also in the different contexts. There are multiple states, for instance, in which basically you don't have any incentive to be a good teacher, not just a good professor, which basically also there are no specific training to be teacher, apart from being a professor of international law like an academic. On the contrary, we know how in other states, we just discussed with Jed, that the way in which you teach is also assessed in terms of promotion. So, of course, we can. I'm much more on support of the approach in which teaching is taken seriously, but that's something which sometimes is not an asset for your academic career. So maybe Christine, you can have the last question, and maybe you can add short answer.
Thanks. So in terms of the, I was thinking about what recent challenges we are we need to respond to as educators. And I was thinking of ChatGPT and other LLMs, so large language models, with LLM being, of course, very confusing acronym for international lawyers. So at Warwick, we had a poll on how many students use ChatGPT or similar LLMs, and over 90% said that they use ChatGPT more as a research assistant, but it does, of course, for us as educators and those marking assessments, raise questions of plagiarism. So I think we know as educators that we can't ignore AI. And at the same time, we also don't want to accept it unquestioningly. So I'm curious as to hear from you how you're using AI, if at all, or how you anticipate using it. I imagine that this will also lead to a whole new aspect to the literature on teaching international law. And I wanted to sort of set a constructive tone in terms of how we might use AI, I wanted to share two examples. So a friend in Australia has asked students to put an international law essay or problem question into ChatGPT, see what it spits out, and then critically engage with that. So that is the form of assessment, which I think is a very clever way of using it. Another friend who supervises in the digital humanities, not in law, but here at the University of Cambridge, had suggested that students provide two answers. So one which is in their own words, and then the more polished version, which is which has been spat out through ChatGPT, which I think is also a very clever way of just making visible what ChatGPT can potentially legitimately be used for, also as an equalizer. So for those students who, if you're instructing in English, who might not be English native speakers and so on. So yeah, so I'm curious as to how you are using AI, how you're dealing with it in your teaching. Yeah.
So we want to affirm that the issue is using ChatGPT openly, even recorded.
I've decided I'm going to redo a lot of my teaching this summer based on ChatGPT. One is the strategy that Christine referred to, which is actually having students put in questions or other things and then analyze what it is, because ChatGPT hallucinates is what the term is. And I did ask students previous year about how well international law applied to cyber attacks. And ChatGPT, it varies each time you ask, actually gave the wrong answer. And some of the students submitted that, or not exactly, but they used it to inform their own. And so that's sort of useful. Some of it, though, is I've gone away from having students doing case briefs alone for a grade, simply because ChatGPT does a pretty good job on Aqua de Bana or anything else that's kind of classic. I still have them do it, but I tell them, one, it's only satisfactory or unsatisfactory, and I specifically tell them that they could use ChatGPT, but they're not going to learn anything. And I use a swimming analogy. You don't learn how to swim by watching other people swim. So you want to develop the kind of skills you need to do on your own, and it's a low risk kind of assignment. And so for the most part, they don't use ChatGPT for my case brief assignments. They might if I started assigning higher grades and things kind of for it. But I also now really have to rethink how to do online writing assignments. I have a series of short ones for them to do, and creating my own hypotheticals, framing it so you can't just get the answer from any kind of internet sources, which I've done, but also ChatGPT. And I need to really rethink kind of how to do that. How can you use it to promote student learning, but how can you make the kinds of assignments that are such that they can't get the canned kind of answers, right or wrong, from using those kind of things. And I admit I haven't quite figured out how to do that.
Okay.
I'm in a very, very, very privileged position that most of the teaching that I do at BICL is not assessed. So this isn't an issue that really comes up in our work. I do a little bit of teaching at the University of Malta, and in that context, we know kind of at the department level that there have been some students that have used ChatGPT. It hasn't been as big an issue or it hasn't come up as big as an issue as I know it has in many other contexts. The idea of using kind of basically putting ChatGPT front and center and saying, okay, put this through ChatGPT, but then critique what ChatGPT gave you, is an important, I think is a really kind of interesting and useful way of engaging with ChatGPT. I think we can't assume that if we tell students don't do it, they won't do it. I think that's gonna that's never going to work, right? So we need to find creative ways of making sure that it is being used, but we know how it is being used, and that it is being used in the same way that, when 10 years ago we would use Google as a tool to help us kind of search for things. We now have much more sophisticated ways of doing that, but that's as far as it can go, because otherwise the students aren't learning too much from it. As I said, I don't have too much experience with it because of the type of teaching that I'm involved in. So.
If you want, Charlotte, perhaps
go ahead, Peter. I'll go after you.
Okay, thank you. No, I can only add that for me, for the moment, ChatGPT is not a competitor to traditional sources. I rather see it as a possible tool to democratize also the access to information. Because we are, of course, in a privileged position that, for example, in our university, we have access to nearly all the databases that are available to all the journals, international journals, so it's no problem. But at other universities, of course, in other countries, they do not have these means. And I think for a first research, it can be useful, even though I can also confirm what Paul said, that it often delivers wrong results. But one never knows what will be in the future. We are only at the beginning of this development. I rather see a different problem in this area with regard to our profession, that perhaps sooner or longer we can be substituted by artificial intelligence. And so this is a real challenge, I think, and especially also on the consideration of the fact that perhaps then we have one teacher worldwide, and what does this teacher then advocate some ideas in the classroom? These are real challenges for us, I think. Many thanks.
So two things that I am working on for an undergraduate class that I'm preparing for the required curriculum of our university's Bush School of Public Policy. So these are now for undergraduates, non-law students. So in some ways, I have a little more freedom with regard to what to do with that group. The trade-off there is one we actually started this conversation with, is that I think the depth and breadth at some level will have to be sacrificed, because you need to focus also on the method. So one thing that I'm trying to do is to really just accept that students will know more about this stuff than I do, or even my colleague who's teaching with me does. And so we're going to try to employ their entrepreneurship to identify for us these tools that they're using, but to bring them back to the classroom then for group discussion in terms of why the tool is useful, not useful, to assess the outcomes and ultimately the content of whatever problem area. To do that, we're also, my colleague and I at the Bush School are redoing the syllabus so that we actually will introduce broad concepts of international law at the same time that we're going to look at content. So we will start with an overview of international law, but we're then going to go into some broad discussion of problems that emerge from the commons. So this would be law of the sea, this would be the space, this would be AI itself. And so forth. So just even as content, we're trying to mix it up a bit so that they can engage with it right away. Out of this, small projects, hopefully the students will then using AI and so forth to bring back to the classroom for discussion, where we'll take that then as the platform of opportunity to discuss. So, what does this mean for jurisdiction or whatever? And then, how do you think this is actually going to advance the problem that is now presented, even in something law of the sea, as settled as one might think of this ancient law that now also has many new dimensions. So I think it's mostly the posing of questions. Since a number of these students will aspire to go to law school, we actually will have them work through cases, but we are going to read opinions together. We will perhaps have an AI version of this because, quite right, Christine and Paul, they produce pretty good results. But we're actually then going to look at broad text and devote an entire class to reading one or two opinions from top to bottom, just to see what the sequence and logic, at least of US opinion as compared to, say, an International Court of Justice opinion and so forth. So we're doing a variety of things, but at the end of the day, time is limited. So we know that we're going to have to trade off a little bit in terms of the amount that we can cover using these different techniques. So we need to develop the toolkit right now, which is where we are, and then come back to how we're going to weave in the content to be sure that at least one has, some basics.
Yeah, since this is being recorded, let me make one kind of point to dispel a myth. To detect students cheating or using ChatGPT, you can't use the standard kind of way of going to Google or otherwise, because ChatGPT gives different answers at different times with different kinds of prompts. And indeed, you can't even use the standard kind of plagiarism software that's designed to detect that as well. The most common one is Turnitin.com that universities often give a subscription service. They've turned off the ChatGPT kind of detection mechanism and things. So not only are students using it, but it really becomes almost impossible to detect that they're exactly using it, except if you repeatedly see the same wrong answers from them, you know that they're getting it from somewhere else. So don't think that you can detect it.
Yeah, that will be the main challenge next period. So Charlotte mentioned that time is limited, and unfortunately that's also the case for our webinar, which is going to end soon. So maybe I have the last question requesting just a 30-second reply, which I also involve Christine and Jed. Basically, it would be, okay, after your work on teaching, especially this research work on teaching, or it was for Jed reviewing it, or for Christine working on entry, and also after having read the other volumes by the other colleagues, what would be one point that you would like to change in your teaching customs, in your teaching tradition of facing with the class? So what, let me say, you learned from your research about teaching, and then you would like now to test in your next teaching class? 30 seconds each.
I'm going to say something about, and it's also linked to the topic of AI that we're discussing, that this also challenges us to make better questions, better assessments that assess higher level skills, and rather than just asking students to show knowledge of international law, but to be able to apply that in a way that they would in legal practice, for instance, or in other areas that they would work. So I would really focus more on how we use international law to develop not just critical thinking, but other practical skills as well. Higher levels of learning, being creative, problem solving, these kinds of things, rather than just being able to state what the law of treaties says, these kind of things. So more about higher level skills can be used in teaching international.
I would say continue my tradition of, in terms of content, of covering less, but doing it better.
Jean-Pierre.
I think skills in terms of both kind of research and writing skills, but also in terms of critical thinking and the various approaches to international law, and kind of putting that front and center so that whatever else we're covering is being looked at from those lenses kind of earlier on.
I think that you can engage with difficult, big issues, but there are some tools that are available, including precepts and practices in international law that allow you to move through some of these issues. So this is a variant of what Paul and Jean-Pierre have just said with regard to critical thinking and problem solving and all of that. So it's just sort of how to begin, how to deal with things that are difficult, uncomfortable, controversial, open-ended, sort of no answer. It's been a problem forever. It remains a problem. Now even a worse problem because we have, more means to kill each other with and so forth. So, but just, how to engage with those problems using the various tools and techniques and concepts and practices that international law provides, which I think is part of the overall toolkit, but now applied through AI and, many other tools that we cannot even imagine at this moment. So.
Peter and Christine.
I think I won't change my way of teaching because, for example, issues of critical thinking were present also before I started this research. But of course, this study enriched me very much because it unearthed an enormous wealth of information and insights. And I think that there is still much more to be discovered. And so what I take from these studies, from this project, my determination to continue with studies on teaching of international law. Thank you.
Giulio, you know, in many ways, we see flattening of hierarchies in our subject, and maybe we're actually talking about that in the classroom as well. The interaction between the professor and the student, maybe the hierarchy universe is changing, and this I just thought about as we were discussing this AI stuff. So that even the function of the teacher may be a little different. But anyway, sorry.
I was actually just going to say exactly the same thing, Charlotte. I think listening to our students more, right? So I do find this idea of the flipped classroom really appealing because the students can also inform our teaching in that they say what they care about, and that I think forces us to consider how we are talking about our discipline. I mean, so many of our students today really care about climate justice and the role of international law in that as something that we haven't mentioned yet today. And that was something that I had neglected in my syllabus that I had constructed. And I realized in conversation with the students that they really wanted to learn more about that. So I think listening to our students and maybe flattening that hierarchy, as Charlotte said, in terms of also the content of our of an international law syllabus is a really useful lesson. Yeah.
So thanks a lot for this very interesting conversation, which was of course starting kicked off it through a discussion about these interesting volumes, plus the review by Jed and the entry by Christine. I definitely recommend to have a look at them because, of course, they might provide a lot of inspiring points for improving our teaching activities. So let's hope that also through this inspiration, we could be better teacher in the next future for our students that definitely deserve a major effort from our side, particularly from me. So thanks a lot for joining me, for being here today. We'll continue this conversation about teaching international law in a further series of webinars. And of course, you can soon find this video uploaded in the ESIL website. So at least everyone can benefit from it. So thanks a lot for joining us today. Thank you. Thank you very much. Bye. Okay. Thanks, Christine. Much appreciated.
Thank you. Enjoy your dinner.